Rule 4. Venue. Definition: venue refers to the possible or proper place or places for the trial of a suit as among several places where jurisdiction could be established. What is the difference between jurisdiction and venue? Jurisdiction deals with the authority of a court to exercise judicial power, while venue deals with a place where that power should be exercised. Is venue jurisdictional? In civil cases, venue is not jurisdictional. However, in criminal cases, it is. What is a real action and what is a personal action? A real action is an action affecting title to or possession of real property or interest therein. Any other action is a personal action. What is the venue of real actions? Real actions shall be commenced and tried in the proper court which has jurisdiction over the area wherein that real property involved or a portion thereof is situated. Forcible entry and unlawful detainer actions shall be commenced and tried in the municipal trial court of the municipality or city wherein the real property involved or a portion thereof is situated. What is the venue of personal actions? Personal actions may be commenced and tried where the plaintiff or any of the principal plaintiffs resides, or where the defendant or any of the principal defendants resides at the election of the plaintiff. In the case of a non-resident defendant found in the Philippines, the action may be commenced and tried where the plaintiff resides or where the non-resident defendant may be found at the election of the plaintiff. That is Section 2, Rule 4. What is the venue of an action against a non-resident defendant not found in the Philippines? If any of the defendants does not reside and is not found in the Philippines and the action affects the personal status of the plaintiff or any property of said defendant located in the Philippines, the action may be commenced and tried in the court of the place where the plaintiff resides. If action involves the plaintiff's status, of course, or where the property or any portion thereof is situated or found, if the action affects defendant's property. That is Section 3, Rule 4. Note that Section 3, Rule 4 applies to both personal and real actions. Outline the venue rules in action against a non-resident defendant. Venue rules re non-resident defendant or NRD, non-resident defendant. Type of action: if it's personal, the rule is plaintiff's residence or where defendant is found. If non-resident defendant not found in PH, if action number 3, see below. Okay, action number 3 is action affecting personal status or plaintiff or property in defendant in the Philippines. In real action, if the non-resident found in the PH where property is situated, if it's not found, then plaintiff's residence or where property is situated or found. That is Section 3, Rule 4. Q. P. A resident of Manila will file an action to recover title over land registered in the name of D, a non-resident defendant, and who is not found in the Philippines. The land is located in Davao City. May P file the action in Manila? Yes. Under Section 3, Rule 4, if any of the defendants does not reside and is not found in the Philippines, and the action affects any property of said defendant located in the Philippines, the action may be commenced and tried in the court of the place where the plaintiff resides, or where the property is situated. Hence, the action may be filed in both Manila and Davao City. P. A resident of Manila will file an action to recover title over land registered in the name of D, a non-resident defendant, but who is found in the Philippines. The land is located in Davao. May P file the action in Manila? The answer now is no. Section 3, Rule 4 does not apply if the non-resident defendant is found in the Philippines. In such a case, the general venue rule for real actions will apply, and hence the action for recovery of title over land should be filed in Davao City. Another, P, a resident of Manila, will file an action to claim ownership over a bank account in the name of D, a non-resident defendant and who is not found in the Philippines. The bank is located in Davao City. Where is the venue, or where are the venues of the action? The venues are in Manila, where P is the plaintiff resides, or in Davao City, where the subject property of defendant D is found. Under Section 3, Rule 4, if the non-resident defendant is not found in the Philippines and the action affects any property of said defendant located in the Philippines, the action may commence or may be commenced and tried in the court of the place where the plaintiff resides or where the property is situated or found. Another scenario, P, a resident of Manila, will file an action to claim ownership over a bank account in the name of D, a non-resident defendant but who is presently staying in a hotel in Cebu City while on vacation. The bank is located in Davao City. Where is the venue of the action? The venue may either be in Manila, where the plaintiff P resides, or in Cebu City, where the defendant D is found at the election of P. Under Section 2, Rule 4, in a personal action against a non-resident defendant found in the Philippines, the action may be commenced and tried where the plaintiff or any of the principal plaintiffs resides or where the non-resident defendant may be found at the plaintiff's election. Q. D, an American citizen, borrowed $500,000 from P, a Filipino citizen, while vacationing in the Philippines. D failed to pay. D went back to the United States. May P file a suit in the Philippines against D? The answer, unfortunately, is no. D is a non-resident and he is not found in the Philippines, nor does the action affect P's personal status or any property of D located in the Philippines. A Philippine court cannot acquire jurisdiction over a non-resident defendant in an action in personam. For purposes of the rule on venue, what is the residence of a corporation? The residence of a corporation is its principal place of business, not its branch office. Florence D. Regalado. D, a resident of Cebu City, borrowed $1 million from C, a resident of Los Angeles, California. D did not pay C despite demands. C engaged attorney B, whose office and residence is in Quezon City, to file a collection case against D. C executed an SPA authorizing attorney B to prosecute a case in his favor. C filed a collection case before the RTC of Quezon City. D filed an answer raising affirmative defense of improper venue, arguing that none of the parties reside in Quezon City. Was venue improperly laid? The answer is yes. In a collection suit brought by a non-resident plaintiff as represented by his attorney in fact, the real party in interest is the plaintiff pursuant to Section 3 of Rule 3. Hence, the venue should have been laid in the place where the defendant resides and not where the attorney in fact reside. Ang versus Ang. Plaintiff Lawrence Heller, a USA Air Force member, filed with the CFI of Pampanga an action for damages against Dangwa Transportation Company and its driver. The complaint averred that plaintiff was then stationed at Clark Air Base, Angeles, Pampanga. The defendants filed an answer raising the affirmative defense of improper venue. The defendants argued that plaintiff's assignment in the Philippines is temporary since members of the United States Air Force may be assigned any time to any station under the exclusive control and decision of the commanding officer, and that the venue of the action should not be Pampanga, but the city of Baguio or Benguet, Mountain Province, where the defendants reside, was venue improperly laid? The answer is no. Residence for purposes of determining venue under Section 2, Rule 4 simply means a place of abode, whether permanent or temporary. What is of paramount importance is where plaintiff actually resided or where he may be found at the time he brought the action. Here, plaintiff had his actual residence at Clark Air Base, Angeles, Pampanga, at the time he filed his action. Hence, venue was properly laid. Dangwa, Transportation versus Sarmiento. Plaintiff Claridades filed an action with the CFI of Bulacan, where he resides, against Mercader and Fernandez for the dissolution of their partnership. The main asset of the partnership was a fish pond located in Marinduque. Defendants filed an answer in which they alleged that the partnership had so far been unproductive and that this was the result of plaintiff's failure to contribute his share. Defendants counterclaim for damages. Subsequently, the court granted leave to intervene to Sulieta and his wife, who alleged that they had bought the fish pond and were now its owners. Sulieta and his wife were given 10 days to file such pleading as they may deem necessary for the protection of their rights. The Sulietas then filed an answer raising the affirmative defense of improper venue. May the case be dismissed on the ground of improper venue? That's letter A. The answer is no. An action for the dissolution of a partnership is a personal and not a will action, notwithstanding the fact that the main asset of the partnership was the real property. The sale of the fish pond would merely be a necessary incident to the liquidation of the partnership. Hence, the venue was properly laid. Letter B. If the action filed by plaintiff against defendant were a real action affecting title over the fish pond, would your answer still be the same? Answer: yes, my answer would still be the same. The defendants had already waived the objection against improper venue when they did not raise the same in the answer. The court, having legally acquired authority to hear and decide the case, it cannot be divested of that authority by the intervenors. An intervention cannot alter the nature of the action and the issues joined by the original parties thereto. Claridades versus Mercader. 17 Scra 1. Intervention is not an independent proceeding, but one which is merely ancillary to the existing action. Petitioner filed with the RTC of Davao City a complaint for nullification of deed of sale of land against the respondent. The petitioner alleged that he never signed the questioned deed of sale. The subject land is located in Carmen, Davao del Norte. The respondent filed an answer raising the affirmative defense of improper venue, stating that the complaint should have been filed with the RTC of Davao del Norte, which had or has jurisdiction over Carmen, the place where the subject land is located. May the case be dismissed on the ground of improper venue? The answer is no. The complaint for nullification of the deed of sale of land is a personal action, since there was no allegation that the possession and title to the property have been transferred to respondent. Nowhere in the complaint did petitioner allege or pray for the recovery or reconveyance of the real property. Hence, venue was properly laid in Davao City where the parties reside. Rakpan versus Baroga High. 6 June 2018. P filed a complaint against the surety with the RTC of Manila. The surety then filed a third-party complaint against X, who had executed an indemnity agreement undertaking to indemnify the surety in case it becomes liable under the surety bond. X filed an answer to the third-party complaint raising the affirmative defense of improper venue. X pointed out that the indemnity agreement between the surety and X contains a provision that any suit arising from the agreement shall be solely and exclusively filed in Quezon City. Should the court dismiss the third-party complaint? The answer is no. A third-party complaint is ancillary to the main case. Thus, a third-party complaint has to yield to the jurisdiction and venue of the main action. Eastern Assurance and Surety Corporation versus QE, GRL 54452. P. A corporation filed a complaint for annulment of contracts of loan with cancellation of real estate mortgage against D in Pasig, the place where P has its office. P alleged that the contract of loan was without the knowledge of the corporation. P, the mortgager, is still in possession of the real property mortgage. D raised the affirmative defense of improper venue in his answer, contending that the annulment of the real estate mortgage is a real action, since P sought to compel D to accept its payment and thus affecting title over the property and freed from the encumbrance. Thus, it should have been filed with Quezon City, where the encumbered properties are located. Is a complaint for cancellation of real estate mortgage a real action? The answer is no. The instant action to annul a contract and its accessory rem is a personal action. An action for cancellation of rem is a personal action if the mortgagee has not foreclosed the mortgage and the mortgager is still in possession of the premises, as his title to or possession of the property is not in dispute. Here, there was no foreclosure yet, and the mortgager was still in possession of the realty mortgage. TUA versus Total Office Products and Services. Eduardo, a resident of the city of Manila, filed before the Regional Trial Court of Manila a complaint for the annulment of a deed of real estate mortgage he signed in favor of Galaxy Bank and the consequent foreclosure and auction sale of his mortgage Makati property. Galaxy filed a motion to dismiss on the ground of improper venue, alleging that the complaint should have been filed with the RTC of Makati since the complaint involves the ownership and possession of Eduardo's lot. Resolve the motion with reasons. The motion to dismiss on the ground of improper venue should be granted. Under the rules of civil procedure, the venue of real actions shall be with the proper court having jurisdiction over the area where the real property involved is situated. An action for annulment of mortgage is a real action if there has already been a foreclosure sale. TUA versus Total Office Products and Services. Here, there was already a foreclosure sale. Hence, the action for annulment of mortgage is a real action which should have been filed in Makati where the real property is situated. A brings an action in the Metropolitan Trial Court of Manila against B for the annulment of an extrajudicial foreclosure sale of real property with an assessed value of 50,000 located in Laguna. The complaint alleged prematurity of the sale for the reason that the mortgage was not yet due. B timely moved to dismiss the case on the ground that the action should have been brought in the RTC of Laguna. Decide with reason. And so far as the motion to dismiss is based on improper venue, since it argued that the action should have been brought in Laguna, the same should be granted. The action for annulment of the extrajudicial foreclosure sale of real property is a real action since there has been a foreclosure sale and thus the action affects title to the real property mortgage. The same case. Hence, the venue lies in Laguna, the place where the real property is situated. BPI Family Bank filed with the RTC of Manila an action to recover deficiency against the real estate mortgagors after the extrajudicial or extra foreclosure sale had resulted in deficiency. The realty mortgage was located in Manila, while BPI-FB has its main office in Makati. The mortgagors filed an answer raising the affirmative defense of failure to state a cause of action, res judicata, and waiver. The RTC denied the affirmative defenses. The mortgagors filed a motion for reconsideration wherein they reiterated the previous grounds and added the ground of improper venue, contending that the action for deficiency was a real action which should have been brought in Manila. The motion for reconsideration was denied. The mortgagors went up to the CA on the petition for certiorari. The CA granted the petition and ordered the dismissal of the action on the ground of improper venue, holding that it was a real action which should have been filed in Manila. Was the CA's decision correct? The answer is no. The CA's decision was not correct. First, an action to recover the deficiency after extrajudicial foreclosure of a real estate mortgage is a personal action since it does not affect title to or possession of real property or any interest therein. Hence, the action was properly brought in Makati, where the mortgagee has its main office. Second, even assuming that there was improper venue, the ground was waived by the mortgagors since they did not timely raise it in their answer. Here, the ground of improper venue was raised belatedly in the motion for reconsideration, not in the answer. Hence, the objection was waived pursuant to Section 1, Rule 9. BPI Family Bank versus U. Dewey Co. 22 July 2015. Q. A and B, both residents of Batangas, entered into a contract of lease over a parcel of land belonging to B, located in Calapan, Mindoro. A filed a complaint before the RTC of Batangas City for the rescission of the lease contract of land in Mindoro. B filed a motion to dismiss on the ground that the Batangas court did not have jurisdiction over the subject matter, the land being located in Mindoro. B, however, did not allege improper venue in his motion. This side with reason. Motion to dismiss denied. The ground that the Batangas court did not have jurisdiction over the subject matter is without merit, as the regional trial court has jurisdiction over actions incapable of pecuniary estimation under BP 129. An action for rescission of contract is one which is incapable of pecuniary estimation. The more pertinent ground for the motion to dismiss was improper venue. However, under Section 2, Rule 9, defenses and objections not raised in the motion to dismiss are deemed waived. Here, the defenses on improper venue was not alleged in the motion to dismiss. Hence, B is deemed to have waived the same. Even if the motion to dismiss were to be considered as substantially raising the defense of improper venue, the motion would still be denied. The action for rescission of the lease contract is a personal action, since the complaint filed by the lessee did not pray for the recovery of possession of the land. Hence, the motion to dismiss would still be denied. When is Rule 4 on venue of actions not applicable? In those cases where a specific rule or law provides otherwise. Number 2, where the parties have validly agreed in writing before the filing of the action on the exclusive venue thereof. Give examples of causes where a specific rule or law provides otherwise. 1. Civil and criminal actions for libel shall be filed with the RTC having jurisdiction over the place where the libelous article is printed and first published, or where any of the offended parties actually resides at the time of the commission of the offense. Article 360 of the RPC. Article 360 also provides for special venue provisions if one of the offended parties is a public officer whose office is in Manila. Petitioners for declaration of nullity of an annulment of marriage shall be filed in the family court of the province or city where the petitioner or respondent has been residing for at least 6 months prior to the date of filing, or in case of a non-resident respondent, where he may be found in the Philippines at the election of the petitioner. Section 4, Supreme Court rule on declaration of absolute nullity of void marriages and annulment of voidable marriages. Same venue for filing petition for legal separation. Petitioners for rehabilitation shall be filed in the RTC having jurisdiction over the territory where the debtor's principal office is located. Section 2, Rule 3, Section Interim Rules of Procedure on Corporate Rehabilitation. Number 4, cases governed by Section 1, Letter A of the Supreme Court Interim Rules of Procedure governing intra-corporate controversies shall be filed in the RTC having jurisdiction over the principal office of the corporation, partnership, or association concerned. Number 5, a petition for deposition before action shall be filed in the court of the place of the residence of any expected adverse party. Section 1, Rule 24. In a small claims case, if the plaintiff is engaged in the business of lending, banking, and similar activities, and has a branch within the municipality or city where the defendant resides, the statement of claims shall be filed where that branch is located. Section 7, Rules of Procedure for Small Claims Cases. Q. The deed of real estate mortgage between the mortgagors and the mortgagee, provided that any and all actions arising therefrom shall be in Makati City. The mortgaged land is situated in Paranaque City. Upon default, the mortgagee filed a petition for extrajudicial foreclosure with the clerk of court of Paranaque City. The mortgagors moved to dismiss the case on the ground of improper venue. Should the motion to dismiss be granted? The answer is no. Exclusive venue stipulation cannot apply in a petition for extrajudicial foreclosure. Under Act 3135, the sale can be made only in the place where the realty is located. Section 4, Rule 4 does not apply since an extrajudicial foreclosure is not an action. Ochoa v. China Bank. Q. P applied for 6 cellular phone subscriptions with PILTEL. P later filed with the RTC of Iligan City a complaint for sum of money and damages against PILTEL. The latter raised the affirmative defense of improper venue, citing the common provisions in the subscription agreements which provide that venue of all suits arising from this agreement shall be in the proper courts of Makati City. Subscriber expressly waives any other venue. Should their affirmative defense of improper venue be granted? Yes. Exclusive venue provision was held to be valid by the Supreme Court. The Supreme Court distinguished this case from Sweet Lines v. Teves, 83 SCRA 361, in which the plaintiffs were virtually compelled to buy tickets from Sweet Lines, otherwise they would be stranded in Bohol. Here the plaintiff had unfettered freedom to sign or not sign the subscription agreement. P. Petitioner, Paglawam Management and Development Corporation, or Paglawam, is the registered owner of 3 parcels of land located in the province of Cebu. In 1994, Union Bank extended HealthTech a credit line in the amount of 10 million. To secure its obligation, Paglawam executed 3 real estate mortgages in favor of Union Bank. Section 9 of the Real Estate Mortgage Deeds provides as follows. Section 9 Venue. The venue of all suits and actions arising out of or in connection with this mortgage shall be in Makati, Metro Manila. The parties hereto waiving any other venues. May Paglawam file an action for annulment of the mortgages with the RTC of Cebu City? The answer is no. The phrase waiving any other venue means that the parties have agreed that the venue of all actions arising from the mortgage shall be in Makati City. Paglawam Management Corporation versus Union Bank. Q. Lessor filed a complaint against lessee with the RTC of Valenzuela City for collection of unpaid rental amounting to 8 million. The lease contract provided that all actions filed in connection with this lease shall be filed with the RTC of Pasay City. Exclusive of all others, lessee filed several motions for extension of time to file a responsive pleading, and when he eventually filed his answer, it contained a counterclaim and third-party complaint. In his answer, the lessee raised the affirmative defense of improper venue. May the case be dismissed on the ground of improper venue? The answer is yes. The venue stipulation is a restrictive or exclusive one. Hence, any action arising from the lease contract shall be filed only in the RTC of Pasay City. The respondent had filed several motions for extension of time to file a responsive pleading, or that he interposed a counterclaim of third-party complaint in his answer, does not necessarily mean that he waived the affirmative defense of improper venue. There is no inconsistency in seeking dismissal of the main complaint while pursuing one's counterclaim or third-party complaint in the same case. Lay Construction Corporation versus Sedano. PBCom filed a collection case against D before the RTC of Manila. PBCom's place of business, based on the surety agreement or SA executed by D in relation to a credit line PBCom extended to International Trading Company. However, in the promissory note executed by ITC, it was expressly stipulated that the venue for any legal action that may arise out of said promissory note shall be Makati to the exclusion of all other courts. Do you raise the affirmative improper venue? Should the affirmative defense be granted? Yes. Under the contemporary contracts construed together doctrine, an accessory contract must be read in its entirety and together with the principal agreement. The SA or surety agreement can be enforced only in conjunction with the promissory note. The venue stipulation in the promissory note thus only applies to the surety agreement as an ancillary contract to the promissory note. The venue should be laid in Makati. Philippine Bank of Communications versus Lim, GR 158138. Q. Respondent entered into a payroll agreement with the bank. The agreement contained a venue stipulation which reads thus: in case of litigation, venue shall be in the proper trial court of Manila for determination of any and all questions arising hereunder. A dispute arising from the payroll agreement between respondent and the bank ensued. Respondent filed an action for damages with the RTC of Quezon City, where he resides. The bank raised the affirmative defense of improper venue. Should the affirmative defense be granted? The answer here is no. The venue stipulation here is not exclusive, but merely permissive, for it does not contain the words expressing the intent that Manila is an exclusive venue, like exclusively or solely. Hence, the filing of the case in Quezon City, where the plaintiff resides, is proper. Philippine Bank of Communications versus Tarazo. Gianna is the president and general manager of AirSwift International, a single registered proprietorship engaged in the freight forwarding business. Mangila engaged the service of Gianna to transport goods, but she did not pay Gianna. Gianna thus filed a collection suit against Mangila before the RTC of Pasay City, where AirSwift holds office. Gianna resides in Paranaque City, where Mangila resides in San Fernando, Pampanga. Mangila raised the affirmative defense of improper venue. She points to a provision in Gianna's invoice which contains the following venue provisions. Number 3. If court litigation becomes necessary to enforce collection, the agreed venue for such actions is Makati, Metro Manila, Philippines. Should the affirmative defense be granted? Explain. The answer is yes. The affirmative defense of improper venue should be granted, although for a reason different from that invoked by Mangila. Under the rules of civil procedure, the venue of a personal action is in the residence of either the plaintiff or the defendant. Here, what is involved is a collection suit, which is a personal action. However, neither the plaintiff, Gianna, nor the defendant, Mangila, resides in Pasay City. The fact that AirSwift International holds office in Pasay City is irrelevant since a single proprietorship does not possess juridical personality and thus cannot be a party to a suit. Hence, Pasay City is not the proper venue for the action. The venue stipulation is not the proper basis for dismissing the case on the ground of improper venue. The Supreme Court has held that a venue stipulation which does not contain words of exclusivity is merely a permissive venue stipulation which simply provides for an additional venue. Hence, the case may not be dismissed for improper venue on the basis of the venue provision since it is not exclusive. The case, however, may be dismissed on the ground of improper venue because it was not filed in the residence of either the plaintiff or the defendant. Mangila versus Guyana, 12 August 2002. Q. How may the ground of improper venue be raised by the defendant? How may the ground of improper venue be raised by the defendant as an affirmative defense in the answer? Section 12, note letter A, Rule 8, 2020 Rules of Civil Procedure. It may no longer be raised in a motion to dismiss. That's Section 12, letter A, Rule 15, 2020 Rules of Civil Procedure. May the trial court dismiss a complaint motu proprio on the ground of improper venue? The answer is no, since if the defendant does not raise the objection of improper venue in the answer, he is deemed to have waived it. However, in cases governed by the rules on summary procedure and in ejectment cases, the trial court, instead of issuing the summons, may, from an examination of the allegation in the complaint and such evidence as may be attached thereto, dismiss the case outright on any of the grounds for dismissal of a civil action which are apparent therein, including improper venue. Section 4, Revised Rules on Summary Procedure. Under the revised rules of procedure for small claims cases, after the court determines that the case falls under such rules, it may, from an examination of the allegations of the statement of or claims and such evidence attached thereto, by itself, dismiss the case outright on any of the grounds for the dismissal of the case, including improper venue. If during the hearing the court is able to determine that there exists a ground for the dismissal of the statement of claims, the court may itself dismiss the case even if such ground is not pleaded in the defendant's response. Section 11 of the Revised Rules of Procedure for Small Claims. Petitioner was born in 1989 in Sabah, Malaysia. It was only in 2008 that her mother reported her birth to the Philippine Statistics Authority in Quezon City. However, her birth year was erroneously recorded as 1980 instead of 1989. She filed a petition under Rule 108 with the RTC of Davao City, where she resides, to correct her year of birth in her report of birth. The RTC motu proprio dismissed the petition on the ground of improper venue, stating that under Section 1, Rule 108, the petition should have been filed with the RTC of Quezon City. Was the dismissal correct? The answer is no. Venue is procedural, not jurisdictional, and hence may be waived. It was erroneous for the RTC to motu proprio dismiss the petition before it on the ground of improper venue, since convenience is the raison d'etre of the rules on venue, and as it was established that Davao City is the residence of petitioner, and as further pointed out by the OSG, PSA has a field office located in Davao City. It is the most convenient for the parties. Moreover, it is well settled that courts may not motu proprio dismiss the case on the ground of improper venue without any objection at the earliest opportunity, as in a motion to dismiss or in the answer. It is deemed waived. The OSG did not register any objection to the venue of the petition. Cabrera versus Philippine Statistics Authority, June 3, 2009. Wow, we're done with Rule 4. Rule 5, Uniform Procedure in Trial Courts. Rule on Summary Procedure. Q. What civil cases are governed by the rules on summary procedure? 1. Ejectment cases. 2. Cases where the total amount of the plaintiff's claim does not exceed 100,000 or 200,000 in Metro Manila, exclusive of interests and costs. Note, however, that if the claim falls under the coverage of the rules of procedure for small claims cases, as in those arising from the contract of lease, mortgage, loan, services, or sale, it is that rule which governs. Note also that probate proceedings are not governed by the rule on summary procedure. Q. What are the pleadings allowed under the rule on summary procedure? The only pleadings allowed under the rule on summary procedure are the complaint, compulsory counterclaim, cross-claim, and the answers thereto. All pleadings must be verified. What are the prohibited pleadings, motions, and petitions under the rule on summary procedure? TM, PR, PIRC. Motion to dismiss or quash except where the ground is non-referral to barangay conciliation and lack of subject matter jurisdiction. Number 2, motion for bill of particulars. Number 3, motion for postponement, which are dilatory. Number 4, motion for reconsideration of a judgment, reopening and new trial. 5, motion for extension of time to file pleadings or papers. 6, motion to declare defendant in default. 7, third-party complaint. 8, memoranda. 9, petition for relief from judgment. 10, intervention. 11, reply. 12, certiorari, prohibition, and mandamus against interlocutory orders. In an ejectment case, the court dismissed the complaint for failure of the plaintiff to appear during the preliminary conference. The plaintiff filed a motion for reconsideration of the dismissal order. The defendant contends that the dismissal had become final and executory since the motion for reconsideration is a prohibited pleading and hence does not suspend the reglementary period to appeal. Is the defendant's contention correct? The answer is no. The motion for reconsideration prohibited under Section 19, letter C of the Rule on Summary Procedure is that which seeks reconsideration of a judgment rendered by the court after trial on the merits. The dismissal order is not a judgment on the merits after trial of the case. Lucas versus Fabros. Q. P filed with METC of Las Piñas City a suit against D to collect the sum of 100,000. The METC rendered judgment in favor of P. D appealed to the RTC, which affirmed the challenged decision. D filed with the Court of Appeals a motion for extension of 15 days to file a petition for review. May P in the meantime move for the execution of the judgment as a matter of right? The answer is yes. The decision of the RTC in civil cases covered by the Rule on Summary Procedure shall be immediately executory without prejudice to a further appeal that may be taken therefrom. Section 21, Rule on Summary Procedure. Revised Rules of Procedure for Small Claims Cases. Q. What cases are governed by the Revised Rules of Procedure for Small Claims Cases? Answer. These rules shall govern the procedure before the MTC in actions for payment of money where the value of the claim does not exceed 300,000 or 400,000 in metropolitan trial courts exclusive of interest and costs. When shall the MTC apply the revised rules of procedure for small claims cases? The MTC shall apply the rules in all actions which are purely civil in nature, where the claim or relief prayed for by the plaintiff is solely for payment or reimbursement of sum of money. The claim or demand may be for MLB. MLB means for money owed under a contract of lease, loan, services, sale, or mortgage. L. For liquidated damages arising from contracts. B. The enforcement of a barangay amicable settlement or an arbitration award involving a money claim covered by the rules pursuant to Section 417 of the Local Government Code. Are the rules of civil procedure applicable to small claims cases? Yes, but only suppletorily insofar as they are not inconsistent with the rules. How is a small claims action commenced? A small claims action is commenced by filing with the court an accomplished and verified statement of claims. What are the venue rules for small claims cases? The regular rules on venue shall apply. However, if the plaintiff is engaged in the business of banking, lending, and similar activities, and as a branch in the municipality or city where the defendant resides, the statement of claims shall be filed where that branch is located. What are the prohibited pleadings and motions in small claims cases? The prohibited pleadings and motions are essentially the same as those prohibited under the rule on summary procedure. The only difference is that motions to dismiss on whatever ground are prohibited in small claims cases. Section 16. May the defendant file a permissive counterclaim? Yes. The defendant may also elect to file a counterclaim against the plaintiff that does not arise out of the same transaction or occurrence, provided that the amount and nature thereof are within the coverage of the rule and the prescribed docket and other legal fees are paid. Section 15. Q. Are decisions in small claims case appealable? No. Decisions in small claims cases are final, executory, and unappealable. Section 24. An aggrieved party may, however, resort in appropriate cases to a special civil action for certiorari in case of grave abuse of discretion amounting to lack of or excess of jurisdiction. AL Ang Network Incorporated versus Mondejar, January 2014. The petition for certiorari shall be filed with the RTC. Since a motion for reconsideration is a prohibited pleading, a party must file the petition for certiorari without filing a motion for reconsideration of the judgment. Do the rules on mediation or judicial dispute resolution apply to small claims cases? No, inasmuch as the parties may enter into compromise at any stage of the proceedings. That ends rule number 5. Next upload will be rule number 6, kinds of pleadings. And if you're not yet subscribed to our channel, go ahead and hit that subscribe button and let's study together. Hey, and please forgive me for the mispronounced words and no edits on my recent uploads because we are just on rule 5 now out of rule 71. Thank you for your understanding. If you have any suggestions or comments, please drop your comments below and I will read them. Thanks.